Hi, I'm David Boundy. Spent many years in law firms, largely as a midwife for new companies, representing venture capitalists, representing investors, investing in new companies, a fair number of times representing the company as they did an IPO, seeing how patents really play out in the market, getting businesses going. From my point of view, what patents are about is taking ideas. Ideas are cheap. There are thousands of ideas that come everywhere. What matters, an idea is worthless until it's a company, until it's a product, until it's something you can buy and put in your pocket, until it's something that can frustrate all of the video people here, right? As an idea, it's worthless. What a patent allows to happen is an investor comes in and says, I like that idea enough that I'll put money behind it and turn it into a product. And because of the patent, you've got a sustainable competitive advantage. The profits will flow to us instead of a competitor, somebody else who reverse engineers it. And this is really crucial. All investors, I now work for Wall Street, one of the largest Wall Street companies. We got no bailout money. But investment only happens when an investor sees some kind of competitive advantage, sometimes an unfair advantage that will maintain a stream of profits for years. There are other goals in the patent system. Incentivizing invention, well, that isn't so important because inventions happen. Disclosure, sure, that's important. But this is the big dollars. This is the big dollars. There are many years of my career where I have moved more money through the patent system on behalf of investors than the entire federal judiciary. More than all of the damages of all of the patent cases. I'm one little lawyer. I was an associate. I wasn't even a partner. Investment is where the dollars are, and this is what's important about the patent system. A striking thing about how investment works, the people that make investments, there are tens of thousands of options out there. If you change the economics of any particular investment by a couple percent, investment goes somewhere else. Every investment decision is made at the margin. Very small changes in investment economics have very large changes in investor behavior. And it's even more true in startup companies because you have one lead investor who does the research and says, I like that idea. And then goes out and finds several other people, and they all hold hands and jump together. So if you lose that one lead investor, you've lost many investors. So just the snowballing effects of changing perceptions of patent-driven investments will be very, very large. 20% of our current economy is based on companies that didn't exist 30 years ago. So just the potential effect of a change in the patent system is very large, and the sensitivity to small changes is very large. And I'm worried. But my job here today is to tell you what are some of the things that you as entrepreneurs, as engineers, as patent attorneys can do to cope with this, to reduce some of the risks. Well, this is something I don't expect you to read here on the slide. It's in the handout. For those of you that see it on the web, there's, the larger materials are on the IEEE website. Who are the losers? That is, who's better off under the 52 Act? Who are the winners? Key is that disruptive innovations and inventions that take a long time to develop and test and get the bugs out and decide whether this is a good invention or a bad invention. Do we go this route or do we try something else? All of those are preferentially treated under the 52 Act. The winners under the 2011 Act are the incremental improvement inventions. Replacing a hex head nut with a slotted screw, replacing a methyl group with an ethyl group. Inventions that you can conceive and test, and you have the idea at 10 o'clock in the morning, you build a prototype, it works by 5 o'clock, you call the patent attorney, and you've got a patent application filed by the end of next week. Those inventions are preferentially treated under the new Act. Another thing that we'll see is that under the old law, things that had to happen across multiple companies. So what open innovation, where you have companies with different expertise. The iPhone, for instance, that's a collection of a lot of ideas from a lot of places coming in together and the inventions teaming. Or startups where you need to find an investor and you need a manufacturing partner and you need a marketing firm to help you bring your, all those kinds of inventions were easier to deal with under the 52 Act. The 2011 Act has much stronger protections, it's got very strong protections. If you can do everything within one company, then the 2011 Act gives much stronger preferences and much stronger protections for those kinds of invention models. This is all in the handout. I'll let you look at that. So, all right, so the folks that came today, you're here because you work with startups or small companies or that kind of thing. How have you, the fundamental message here is the way that you have been doing your inventing and your patenting and your business for, since 1870. Starting in March 2013, it's a whole new world. You have to do things very differently. As a startup, startups, you're always an inch from insolvency, right? And so you manage your cash very carefully. And so the best practices have been balancing your R&D procedures and your scheduling and your funding and all of that stuff. You have all of these balances. And in particular, the 1952 Act had what the lawyers in the room call Section 102A. It's the part of the grace period that says you had an invention today, documented, but now you have the fact that you conceived the invention, you've got some locked-in rights. You don't have to do anything. Just the mere fact that you had the idea and started working on it gives you a certain amount of locked-in right. That gave you the opportunity to talk to outside investors. You can go to an investors forum. All the investors walk into one end of the room. We have these at MIT every month. And the inventors walk in at the other end. Everybody sets some ground rules, and everybody talks openly. And because that 102A grace period, you have the time to talk. You have an idea, you can perfect it, you can test it. These are all the things that you've been doing since 1870. When an employee departs, no big deal. You've got your locked-in rights. It's that 102A and 102E grace period that because you are the inventor, the rights accrue to you, that's gone. Absolutely gone. And you just have to change your approach. So here's what you used to do. You'd come up with an invention, you'd test a bunch, do a bunch of, all of the trial and error and error and error and try again and trial and error, try again. When you've got an invention that actually kind of works, that's when you file a patent application. Then you do the production stuff, turning that prototype. You might file another patent application there. This is the picture that you know well and that you just plain have to forget because it's gone. Under the 2011 Act, any public disclosure of an invention by anyone at any time bars your patent rights with two very small exceptions. One is if you can prove that it came from you as the inventor, notice where the burden of proof is, then that's not a disclosure, then that doesn't raise a bar for a year. Or if you present a publication, you make some kind of public announcement of the invention, that locks in your rights against the world for a year. Now the problem is, they all look good on paper. But in the practical reality, once you start playing out how the facts will actually work out and what you have to do as a matter of legal procedure to make any of those new grace periods work, they're too expensive, they're too risky, and as we'll see, the procedures aren't there, so you just basically have to ignore them. So there was the old model where you certainly file one, you might file 2 patent applications. Your new model is you have to file a patent application very early when you have a conception. After you test, you might have to take all of your bad ideas because you haven't tested them yet. You know you got one good idea and 4 bad ideas, but you don't know yet which one it is. You probably are going to have to at least consider filing multiple patent applications. You're going to, now you're going to test, you're going to pursue this one, do a little bit more coding. You may need to take one of these 4 and flesh it out into another one, and another one, and another one. Because the only act that you can do that really locks in your patent rights is filing a patent application. The fact that you invented it is no longer legally relevant. Here's the big difference between the 2 acts. Under the 52 Act, the most legally relevant facts are under your control. As a business, you have the facts in your possession. You can make the facts, you can control them, and it's just like any other business risk. You can get where you need to go to hedge your own risks. The problem is that under the 2011 Act, the facts that determine your patentability are largely out of your control. They're generated by third parties who, by the way, aren't sending you postcards a week in advance to tell you what they're up to. And so the problem is that the standard tools that I, as a business lawyer, advise my client on every other business kind of thing, those standard tools for managing risk don't work. One of the analogies I have given people is that under the old law, you have an idea. It's like a dog on one of those long leashes, the extendable leashes. You can let the dog, your idea, go sniff what it needs to sniff. It can go talk to investors. It can do all those things, but you've got a leash on it. And it's still yours because of 102A. Under the new law, that leash is cut. Once you let that idea go talk to anybody else, that leash is effectively cut. The only thing you can do now is you take your dog and you have to put it in a cage. Every time you leave the house, you have to put it in a cage. One of the big uncontrollable risks is the legal risk. Professor Wegner, interestingly, has been one of the people that's written about that. Drafting ambiguities are the hallmark of this legislation. We've had a pretty stable patent law since 1870. When a client comes into my office, I can say, here's the boundary. You can go right up to the edge of it. I know exactly how to advise you. We can make this work. If you have a lot of money to spend on this, we can do certain things. If you have low money, we do other things, but we can manage the risks. But I know where the boundaries are. The problem is, there are huge ambiguities in the statute. It's a travesty of drafting. And the list of ambiguities are in the handout. And the problem is that a business can't work efficiently in an area of ambiguity. That's what MBA school is about, is teaching you the skills to deal with uncertainty. But legal uncertainty, especially when we've had 140 years of legal stability, is just going to make it very challenging. A friend of mine, Ron Katz-Nelson, if you know him, pulled all of the Supreme Court cases in this area for 220 years, there have been about 30 of them. 20 of them fell between 1870 and 1890. 1870 was the last major change to the statute. A major change means ambiguities that require Supreme Court interpretation to straighten them out. That's going to take 20 years to get this straightened out. And so you have these uncontrolled, so you're going to have to, lawyers are going to have to advise your clients, look, I don't know what the law is. I know it could be this or this. And so most of the time we have to take a conservative approach and assume that the law will be ambiguous. There have been, some people have been saying that the Patent Office will issue rules to interpret that law. But this is an area where the Patent Office has no substantive rulemaking authority. The Patent Office simply does not have jurisdiction to clarify these ambiguities. And last time they attempted to interpret a statute like this, 3 or 4 years ago, the court shot them down because they don't have jurisdiction in this area. And if they try to issue interpretive rules, they won't be given Chevron deference because the agency does not have substantive rulemaking authority in this area.
What's Chevron deference?
Administrative law. It's when an agency says, here's what we think the law means, subject to a fair number of tests, courts are required to defer to the agency's interpretation. So this is not one of those areas. Other things that create uncontrollable risks. Suppose you have an invention and you didn't attend the lecture today and you don't fully appreciate how the law has changed. And, after all, the proponents of the bill have been saying, hey, we gave a robust grace period for inventors for 1 year. I'll rely on that. So you go out and you sell your coffee cup. Well, let's try something a little more complicated. Something you sell an example of your invention in January. Along comes July, somebody else has a similar idea. Not the same idea, pretty close. And sells it in July. November, December comes along, you file a patent application on your invention. What happens? Well, the statute's ambiguous. Nobody knows. But probably the outcome is that third party's disclosure in July is prior art against you. The scope of the patent that you can get, sure, you're entitled to a patent on the one thing you sold. But that next door neighbor competitor product, you can't have a patent to cover it because it's prior art to you. The grace period, yes, it exists on paper, but it's so flimsy you can't rely on it. As a prospective business matter, it's gone. Another, a departing employee or a student who works in your lab, you're a university faculty person, goes out on a job interview. And you don't have a non-disclosure agreement with your students, but they talk to a job, on a job interview. They disclose information, and there's no paper trail back to where that idea originated. But remember that burden of proof. If you want to exercise the derived prong of the safety valve, you have to be able to prove that that idea originated with you. How are you going to do that where there's no paper trail? Elevator conversations, in particular talking with a VC. The conversation with the VC itself probably isn't prior art, probably doesn't create a problem. But you don't have a non-disclosure agreement with the VC. VCs don't sign non-disclosure agreements.
VC?
Venture capitalists. Here's another really remarkable problem. Under the 52 Act, most of the time when you had one of these issues, remember too many buttons. If you ran into one of these problems as an inventor, most of the time what you needed to prove were facts that arose from your own actions. It's pretty easy to prove what you did, right? We all have electronic calendars. We all have all that stuff. It's easy to prove what I did on such and such a date. Under the 2011 Act, the operative facts are not what you did, it's what somebody else thought. The burden of proof is on you to exercise the grace period under the 2011 Act, not to prove what you did, but what the other person thought, when, where they got the idea. And the burden of proof is crucial here because the 2011 Act, the statutes that govern this kind of stuff under the 52 Act were sections 23 and 24. They were the statutes that gave you as an applicant and the patent office the power to compel discovery from third parties to resolve these questions. Well, I kept telling people, you got to fix these two statutes. They didn't get fixed. So, to prove what the other party thought, you have to do it with no discovery, with no subpoena power. So even the statute that is there doesn't work because there's no forum, there's no, in many cases, there's nobody in the patent office and there's no court that has jurisdiction to hear this issue, and there's no procedure to get the evidence you need. So yeah, the statute says there's a substantive right, but there's no procedural way to exercise the right. The grace period is gone. It is gone. You must treat the law as if it were a European, Japanese law. You disclose it, you have to patent first. So what are the results? Well, for instance, in Europe, of 100 patent applications filed, here's the 100% line, about 60% are abandoned either just because new information comes up and you write to the European Patent Office and say, we give up, just dump this, or after the first office action. So something like 60%, because you have to run the patent office, because there's no grace period. In the United States, that's typically been about 20% that have that infant mortality rate. Well, if you're a patent attorney, you've been used to getting roughly 80% yield on the patent applications you file. You need to tell your clients, we're not going to start looking at 30 to 40% yields. Another thing that you can't rely on is provisional applications. Everybody cuts in, this won't be a problem because you can just file a provisional application. The filing fee for a small entity is $115. And what they didn't tell you was, well, yeah, that worked under the 1952 Act. Because under the 52 Act, you can file just any piece of paper, and it's pretty useful to establish your date of invention, to show that leash that you had on the idea that you at least on one day, you were diligent. But conception and diligence are irrelevant under the 2011 Act. The only thing that gives you rights under the 2011 Act is filing a patent application that meets Section 112A, the written description and enablement requirements. A provisional that's just a quick and dirty cheapie, it has no value under the 2011 Act. It had value under the 52 Act. You have to get a patent attorney involved on provisional. But if you're doing that, why file a provisional at all? If you're bearing the costs, just file a non-provisional. Usually, if you have a mature invention and it's done, it's just very expensive to take a two-filing strategy when a one-filing strategy is there. If you have an invention that's, remember it might be valuable to file these as provisionals because you do have a little bit of cost savings. If there's a high likelihood that you're going to dump some of these, it makes some sense to file them as provisionals. The one real value that provisional applications retain is extending patent term out for a year. But provisional applications are just going to be much lower value, much lower use. Another patent Leo has been suggesting, well, use that publication prong of new section 102B to publish a description of the invention and lock in a grace period. It was an academic that wrote it, not a business person. Again, the statute's ambiguous. What does it mean for publication to be a disclosure? It probably means a patent quality, 102A quality, written description, and enablement disclosure. But if you're going to publish a paper with the idea that you're going to exploit section 102B grace period, well, that requires a patent attorney. But by the time you've spent the money on a patent attorney, spend the extra $400 and file a patent application. File $500 and file a patent application. But more importantly, if you're going to publish it in just a plain old publication, this is all about your future business plans. Who wants to publish your full business plan years in advance of when it's going to come out? Now, if you are somebody with monopoly power, this is what Microsoft does, and they have good, valid reason for announcing their business plans. They don't have competitors to tip off. They do have customers to reassure this is where we're going. It's a perfectly good thing for Microsoft to do. But the secrecy of your business plan is one of the most important assets that a startup has. Publication without filing a patent application waives your filing rights in all other countries. So, most startups don't care about U.S. or foreign filing rights because they're very expensive. Foreign patent attorneys aren't going to reduce their rates for you. So you lose a lot by publishing with very little to gain. So the upshot is, don't use this publication route. File a provisional or non-provisional. Take advantage of the 18 months of confidentiality that a provisional or non-provisional gives you. And it's a better source of proof. Remember, you have the burden of proof. What's the effect on clients? Well, clients, file early, file often. And this is awful. I mean, it's just awful, but it's the awful truth. The 52 Act gave you the time that you need, as a business lawyer, right? Getting every business decision is you start out like this. You know that a decision has to be made, but you have no information on which to make a sound business decision. Over time, information comes in and you can figure out, and at some point, you have enough information to make a decision that balances off the business risks, and you make the decision. The problem here is that balance of how much information you need and the urgency of making the decision tips much more quickly. And the time becomes much more crucial. And you just have to accept that your filing decisions have to be faster, which means they will be lower quality decisions. You're going to prune inventions that turn out to be valuable. You'll file applications on inventions that turn out to be worthless. Guess what? Everybody else is in the same boat. At least it's not a competitive disadvantage relative to your American competitors. It means that you've lost your competitive advantage relative to non-U.S. inventors who have been operating under this system. But at least your American competitors are all in the same boat. Almost certainly, from the statistics Ron and I were able to gather, there will be many more applications filed. We guess somewhere between 50 and 100,000. That is between 10 and 20% more applications. They will, on average, be of lower quality. That will make it more difficult for the patent office to examine them. That will drive up examination backlog. The yield will be lower. Right now, about half of the patent office's budget comes from maintenance fees. But if the yield is lower and the examination cost is higher, that means filing fees are going up. A lot. you still have to keep all those good development records. Because between the new derivation proceedings, prior user right defense, trade secret actions, you need all that same development record stuff that you've been keeping anyway. You can't throw that out. In fact, it's probably more important now than it was before. You need new procedures. You know, for years, the patent office has basically been sitting in the back seat of the car. And, Mom, are we there yet? Mom, are we there yet? We're there. Now it's time to do the patent application. Now, remember you all took driver's ed, and you had the second seat with the driver's ed instructor? Well, what did he have in front of him? A brake pedal, right? You're now that person. You're in the front seat because all of the company's activities now, the patent attorney becomes a gating item. There are lots of business actions that you have to have the patent attorney involved, the patent attorney taking action, and the patent attorney stepping on the brake until we get a patent application filed. This is not a role that patent attorneys are comfortable with. We've always been, in that kind of backseat role. You now have to be very in your client's face about, you have to talk to me. You have to tell me when things are happening. You have to give me enough heads-up time that I can file a patent application for you before you make any outside disclosure. Another is departures of key employees. Right? Under current law, you have that leash. Employee departs, you've still got the legal leash you need on the idea. But now, when a key employee leaves, you've got a big hurry up and do something with your patent lawyers. With a couple people, we've figured out, we estimate, one significant figure estimate. It's about $1 billion per year in additional private sector costs. Savings we figured are probably under $100 million, but that's where we think the numbers come out roughly. As a patent attorney, you are going to be in more tension, all of you, more tension with your clients. Who gets blamed for delays? The patent attorney, you're going to want to do prior art searches. They're more valuable now. Who will accept the risk of taking the time to get the prior art search done and digested and read so you know what to do? And for patent attorneys, you've got to talk to your malpractice. Make sure your malpractice coverage up. 3 important things. The deadlines are shorter. They're easier to miss. There are many fewer opportunities to mitigate the harm. The edges are much sharper. You go over the edge, and the recovery, there were a number of recovery strategies available under the 52 Act. Most of them are gone. And most important, the errors under the 52 Act, errors and omissions typically didn't become visible until after the statute of limitations had lapsed. Now they're going to become visible within the 2.5 years of most state statutes of limitations. So, this is something that you as patent attorneys need to deal with. Oh, too many buttons. I guess when I'm done, that's the end of the presentation.
I think he just passed it in.